Hello, I'm Sam Adair with the law firm of Graham Adair, and today I'm joined by my colleague, Bhargavi Kannan,
Hi.
who is going to be talking with us about the proposed regulatory changes to the H-1B process and some of the definitions of the different aspects of the H-1B. Bhargavi, you wrote the piece that we published on our website and on LinkedIn about these changes. So you are de facto our in-house expert. So thanks very much for being here with us today. I'm excited to kind of jump in and talk about this. There are, I think, a lot of things that were in this rule, and there are some specific things that I want to drill down on and focus on today. So let's jump in and start. The first change that I want to talk about were some changes that were related to the definition of specialty occupation and what positions would qualify for the H-1B. So can you talk to us about what the proposed changes would mean to that specialty occupation definition?
Sure. A position will not qualify for H-1B specialty occupation if it requires solely just a general degree without further specialization. So, for example, if a role requires any engineering degree without mention of whether it's electrical or mechanical engineering, that would not qualify for H-1B.
So it narrows the scope a little bit then of what would qualify. Is that a fair statement?
Yes, one thing to note here is that a petitioner may list multiple disparate fields of study, but as long as they're able to establish that these disparate fields of study are directly related to the job duties, that is okay. The petitioner must be able to establish that correlation.
So one of the other sort of key changes to some of the definitions has to do specifically with the definition of an employer for the purposes of the H-1B. So can you talk a little bit to that and what these proposed changes would do to that definition?
Sure. H-1B beneficiaries who are owners in a petitioning organization are eligible for H-1B, subject to certain conditions. So, for example, if a H-1B worker owns more than 50% interest in a petitioning entity, he or she would be permitted to perform duties related to owning and directing a business and non-specialty occupation duties, so long as more than half their time is spent on specialty occupation duties.
Okay, interesting. So that expansion would seem to benefit entrepreneurs, people that are starting their own business and might have
Yeah,
an ownership stake, but can still be considered an employee for the purposes of the H-1B.
exactly.
That's pretty exciting stuff. So another change that I think for the most part is positive relates to F1 students who are on OPT, the optional practical training, or STEM OPT. Can you talk a little bit about what those changes would look like?
Yeah, so the proposed rule promises to give some flexibilities to F1 students by extending their cap gap status until April 1st of the relevant fiscal year rather than October 1st of that same fiscal year. So, what this means is it allows students to have lawful status and also no breaks in employment authorization until they transition to the H-1B.
Okay, that's great. That definitely will help people from having to jump through some of the hoops that they've had to jump through in the past.
Yeah.
So the last thing that I really want to talk about here in terms of changes has to do with the H-1B cap lottery registration process. So this seemed to be like a big focus of this. And in light of just the vast number of applications we saw in last year's H-1B lottery, can you talk a little bit about the changes to the lottery process?
Yeah, of course. This, I'm pretty sure, is what most of you are waiting for. So, to significantly reduce abuse and fraud and to make the lottery system fairer, USCIS would select registrations based on the unique beneficiary and not the number of registrations. So, for example, if a foreign national has 10 job offers and all the 10 employers are entering that foreign national in the lottery, USCIS would still count that as one because it's one foreign national. And all of these companies, if the registration is picked, all of these companies would be notified and they have the option to file the H-1B. So this is a great step, and if this goes into effect, it would be amazing for a lot of people waiting in line for the lottery.
Excellent, thank you. And I guess my last question is, this proposed rule was published a couple of weeks ago for notice and comment. Do we have any sense of when these changes could actually go into effect? Like, how early could we see some of these changes take place?
Yeah, it's important to understand the timeline first before we can speculate on when this would go into effect. So, this proposed rule was published on October 23rd, 2023, and there is a 60-day period where it's open for public comment. And this public comment ends on December 23rd, 2023. And the hope is that these proposed rules go into effect before March 1st, 2024, before the fiscal year, and would be just in time for the lottery next year.
Awesome. Well, thank you so much, Bhargavi,
Sure.
for this insight. I think this has been really helpful. Please like and subscribe this video and to our channel. We'll continue to post updates as there are updates relating to this rule change. We want to make sure that everybody's informed on this. So thank you so much and have a great week.
Yeah.